Whereas your lordship is absolutely right. The whole purpose of enacting 327 was to allow Parliament to occupy the field which will do the nitty-gritty of electoral law.
That's part 320. Dr. Singhvi, let's not argue something which ultimately damages the very constitutionalism. 327 is a power, is a enabling power how to give effect to the constitutional scheme. Today, if you 327 you give such a vast power, then you are also probably arguing something against the basic structure doctrine.
No. 327 is not a power to overturn the constitution. This is answered by a lordship.
327, if 327 lawmaking power
Yes.
can curtail or restrict or define the contours of 324.
No. Now, this is exactly what is answered. Just give me 2 minutes. May I answer? This is a very important question. Your lordship's query is first answered by para 25 of the judgment. Then I'll come to the other paras. Just turn 20. No. First 25. Come to 25 first. Then I'll come to the other paras. Directly answer. Whereas Parliament is also custodian of our rights, not the Election Commission. If at all, Parliament is higher than the Election Commission.
That's right. But
They
Parliament
chose to go so far and no further. Who are you to go further?
Let us see.
They may be wrong,
Like
yeah, Parliament. Your lordship knows, to take a loose, not exactly a direct example, but it's an interesting analogy. Whereas in our Parliament, I happen to be also in the Privileges Committee. So we went into these details. The similar provision is there till such time as Parliament by law. Take out that article. Take out the article. Now Parliament deliberately chose not to make. Because the idea was that the flexibility in the joints of parliamentarians to act in a certain way. So they said that, look, stands codified as it was in England in a certain date, but nobody knows what they were. Parliament is entitled to make law. But since no parliamentary law has actually been born, saying clause A, clause B, privilege means hitting a parliamentarian, obstructing him, no listing is done. That means from case to case, Parliament decides this is privilege or not. Sometimes they do it wrong, sometimes they do it right.
Natural.
But the moment Parliament, the whole debate that it should not do it because you will confine the flexibility of parliamentarians. There's another debate that it's too uncertain. After that Keshav Singh, they said it's too uncertain, you must control it. You can't
understandable. For 327 power is just...
It confines, cribs and circumscribes the power of the EC to act, dehors that on the same subject.
To act in conformity with the constitutional scheme. Tomorrow the parliament says that you take away the particular right of the franchise. Can you?
No, on the contrary, absolutely not. On the contrary, this judgment says they don't collide. They harmoniously operate.
Harmonious, exactly. So the law under 327 will be in furtherance of the cause of 324 to be achieved.
Absolutely. Absolutely. Now, Parliament decided, so that's why I listed 4 features, and there's a 5th feature which I'll be listing just now. Parliament decided to go so far and no further on 4 features. Call my features A, B, C, D. I'll add an E in a moment. They decided the boundary of expanding A, B, C, D till here. Namely, we will not ask beyond 4. If there are individuated objections, we will invite objections from him and he will decide under Form 7. And if the Election Commission wants, we will allow him to do it constituency-wise or part of a constituency on a special revision, is what the word used in 21(3) is. Parliament did not intend to vest in a persona designata the EC. Well, Parliament cannot vest it in somebody else. They are also bound by the Constitution. Parliament has to give it only to the EC. They decided not to vest in the EC the power of what I call en masse decision. That power is for the first time being exercised in these numbers in this manner. That takes away what? That comes to the 5th aspect. It takes away individual adjudication, individual application of mind, individual decision making. There is no way in which a massification, by first creating a rule that you are presumptively there as a temporary guest, and unless you prove, all those arguments will come in, burden of proof is on you, etc., the 3 documentations. The 5th feature flows from the query from the Honorable Chief Justice. Actually, the fifth feature would be, Malas, a invidious discriminatory classification between 2003 people and post 2003 people. In essential treatment, 2003 people are not touched. I can understand that they're given lesser regulatory scrutiny. They're not given lesser regulatory, they are excluded. 2003 to 225, during which in each state, this very election commission has done innumerable revisions. Summary, special, comprehensive, each state 4, 5, we have crossed 23 years, 22 years. During that time, having done so many revisions, you create a new class to which you subject 3 sub-classifications of 2 parents, 1 parent and yourself. And the other class you exclude altogether. So that will actually lead to a further argument of Article 14, sub-classification, which is not valid. Well, no rational nexus can be indicated between those who are there or not, unless, yes, there can be one, that you have become a citizenship tribunal. Be frank enough to admit it, no problem. They will deal with it. Here you are, Malas, trying to masquerade either as a sheep in wolf's clothing or a wolf in sheep's clothing. I don't know which one, Malas. But you are trying to say, I'm only the EC. I'm not a citizenship tribunal. If you are only the EC, in which case, Malas, this classification between 2003 and 2025 can't be a valid classification. In fact, Malas, maybe even the classification of asking me alone, in this category, my 1 parent, and in that category, my both parents. That may not be a valid classification also. Where does the law permit? Where has the law? This is a very major thing. I lose my vote. Well, I said jocularly in the first day, Lordship may have forgotten, that if many of us in this court, including judges, were asked to produce both their parents' birth certificate, I don't know how many advocates or how many judges would have their parents, both their parents. Now that's all right. That's, you can throw it in the dustbin. It doesn't matter. In most cases, you can get an Aadhaar card or a ration card. But where your vote is being lost on that, it's a major consequence. So there are 2 further invidious sub-classifications which may actually hit 14 more, not less. One is 2003 versus 25, and the other is between 2003 and 25, 3 sub-classifications: 2 parents, 1 parent, and alone. Now, Malas, my submission is this. Now, just read 25. This part of harmonious is taken care of by para 25. This is a very important point. 3 learned judges have stood the test of time, Malas. This judgment is, Malas, now almost 50 years old. It's not 50, less than 50, but nearing that. Now just come to, Malas, para 25.
Yes.
At page 55.
Just to sum up therefore.
Yes. This is a very good and a very pointed summary. So A, we are not concerned with, Malas. But it's an important contrast. That's the privileges contrast I gave you, Lordships. A is when there is no parliamentary legislation or rule made under. Rule also is mentioned. Where there is an act and express rules made thereunder, it is not open to the commission to override the act or the rules and pass orders in direct disobedience to the mandate contained. In other words, the powers of the commission are meant to supplement rather than supplant the law in the matter of superintendence, direction and control. And they always say statute and rules. Now, of course, you will decide whether they are doing on the facts of this case. But the principle is clear. The EC is not the boss. The parliamentary law is the boss.